So thank you all for having me again. I appreciate the opportunity to present on this. Very important topic, very timely as well. Just a little bit about our firm. We're a full service law firm. We've been operating for over 40 years. We represent individuals, small and mid-sized businesses, local governments, nonprofits, a wide range of different clients across Western New York. We do have an office in Fairport at Packett's Landing. Right now, most of our clients, most of our attorneys are working remotely. We're doing the best we can to meet everyone virtually by video, phone, or email. But if we do have to meet in person, we prefer to use the Fairport space. A little bit about me. I'm one of our trial attorneys. I help our clients resolve disputes, including personal injury claims. I also do some commercial litigation and work with my colleagues to advise small and mid-sized businesses. So as we get started, as an attorney, it's probably prudent to include a disclaimer. We're going to do some top-level analysis today. This presentation is going to be for informational and educational purposes only. If you do want some in-depth analysis and some one-on-one counseling, please reach out to me directly. I'd be happy to set that up and go in-depth on issues that you or your business may have. So I'm sure a lot of you have seen the news about potential liability related to the coronavirus. Some companies have been facing some criminal investigations. We saw the Attorney General's probing Amazon, claiming that there was an inadequate response to the coronavirus for their facilities. There's also potential civil claims. Walmart was hit with a wrongful death lawsuit from the estate of a worker who died from coronavirus. So the issue that businesses are concerned with is what can you do to help avoid these types of claims and help mitigate your risk or exposure, and that's going to be the general theme of the presentation today. And usually the focus is going to be on civil claims, because that usually has a lower standard of proof as opposed to a criminal claim. So the typical claim that businesses might face in these types of situations is known as a negligence claim. And a plaintiff bringing a negligence claim has to prove 4 elements, the first of which is a duty. And in New York, businesses have a duty to take reasonable measures to limit customers' exposure to dangerous conditions, and that includes exposure to infectious diseases. A plaintiff would have to prove that that business breached that duty to the public and to that individual, and that breach caused their injuries, and in this case, an infectious disease, coronavirus, COVID-19. The classic example that's comparable is kind of a foodborne illness, where if a food producer or distributor or restaurant fails to take reasonable safety measures and someone gets sick and there's an E. coli outbreak or salmonella outbreak, those businesses could be responsible for the injuries that occur, whether it's hospital bills or lost wages or physical and emotional pain and suffering. The damages for these types of claims around diseases can be significant. So the key issue here is what's reasonable for businesses, what's reasonable steps that businesses need to take. Unfortunately, there's no bright line rule, but the burden is on the plaintiff to prove their case. So what do plaintiffs look to? What do defendants look to and their attorneys? We sort of look to what's mandated and recommended for different industries and different businesses. And sort of the key factors there are recommendations from the CDC, state and local guidelines, as well as industry-specific rules. There are specific rules in place and recommendations for the state and the CDC for things like personal services like barbers, as well as restaurants, to a wide range of industries. So what's required for every business is a written safety plan. Whether you're an essential business or a non-essential business, you are required to have a written safety plan available on the state's reopening website at forward.ny.gov. And here's an example of one of the plan templates. You don't have to submit this to anyone. It doesn't need to be approved by anyone, but you do need to have it on file, as well as a date as well, showing when that plan was enacted and put into place by your business or your organization. And the plan should cover several topics. Some examples include physical distancing, how you're going to organize your space, protective equipment that needs to be provided by the business at no cost to your employees. The plan needs to include what your business organization is going to do in terms of hygiene and cleaning. The plan needs to include how you intend to communicate all these issues, including signage throughout your space. as well as a plan for your mandatory daily health screenings for your employees and staff, and finally, contact tracing and a plan for disinfection. You know, if there is a positive case, how are you going to let your customers and guests know? How are you going to inform your employees? And what's the plan to remediate if you're aware of someone who has coronavirus that is in your space? So along those lines, along with a written safety plan, one of the things we recommend for businesses is record keeping. You're required to have a written safety plan. We just went over that. You should be doing daily health screenings for your employees and staff. So if you're going to do those, you should keep records of those to show that you did them. You know, a lot of attorneys say if there's no record, you know, did it really happen? So the best way to protect yourself and mitigate your chances of facing one of these claims is not only doing all these things, but also having a record and recording them as well. So if you have a daily schedule to clean and sanitize your space, you should have a checklist or a way to log when each cleaning was done and by whom, and as well as contact tracing as well to show who is at your place of business or your organization and how can you get in touch with them. Again, this is a reasonable test, so a Wegmans is not going to be required to have the name and contact information of everyone that sets foot in their business. But if you're a small organization, if you only meet with 1 or 2 clients a day or a week, it may be reasonable for you to keep a log of who was in your space and ways to get in touch with them. One of the big issues we're seeing now is waivers of liability, where businesses try and have people who come onto their space waive potential claims. You know, there's some pros for this from the business perspective. It could deter people from bringing a claim, saying, well, I signed a waiver, I really can't bring a claim, I'm not going to talk to an attorney. It can also be a shield that's used as a defense, saying, look, you knew there was a risk coming into this business, you signed this waiver. That could be used sort of against a plaintiff if there is a potential claim. There are some drawbacks to waivers of liability. They're not always enforceable. There's a specific section of the general obligations law that specifically exempts waivers for recreations. So if there's a waiver for skydiving, that might not be enforceable in the state of New York. You know, they may not ultimately be required. We all know that there's a pandemic going on, and every time we go out in public and enter a different business or a different place, we are potentially exposing ourselves to this disease. Any good defense attorney is going to assert that defense at trial and try and put some of the blame or responsibility on the plaintiff. New York has what's known as apportioned liability, so the plaintiff can be partially responsible. Whether they're 5%, 50%, or 100% responsible is up to each case and each specific set of facts. So that's something to keep in mind as well. And then as a practical issue, there may be some potential backlash where consumers coming into your business are saying, well, why are they having me sign this? Are they doing regular cleanings and things that they should be doing? And that may raise some concerns by potential consumers. And that's really more a practical concern for a business to keep in mind if they consider having people sign a waiver if they enter their space. There are some legislative protections in place as well. New York passed the Emergency Disaster Treatment Protection Act that protects healthcare providers and effectively bars medical malpractice claims during the public health emergency. There are some pending legislation right now for other businesses. Last night, the Senate majority released their proposed HEALS Act that contains widespread liability for all businesses and organizations for potential coronavirus-related claims. The response so far in the House of Representatives has kind of been dead on arrival, but it sounds like there's going to be some back and forth and some negotiations, and we could see some federal legislation protecting businesses and organizations for potential negligence claims related to coronavirus. We could see some state claims as well. Some state legislation or possibly some local legislation, but we have yet to see what's happening here, and probably a matter of time to see how those play out. A lot of businesses ask about potential coverage. You know, do I have to pay for these types of claims out of pocket, or will my insurance protect me from a potential claim? It appears that workers' compensation may protect your employees. The big question is whether or not the coronavirus is considered an occupational disease. It may be, so there may be protection there for your employees and staff. Your commercial or premises liability coverage may protect you as well, providing both attorneys to defend you as well as covering potential claims up to your policy limits. That's going to be very specific to the language of each policy, whether or not that may apply. We're getting a lot of questions about business interruption insurance. Those policies typically cover direct physical loss or damage, where if a tree falls on your building and destroys your space, the business interruption insurance would cover your lost profits. So it's not clear, it's unlikely that that type of policy would cover a coronavirus-related claim. Most of these policies, after we saw the swine flu, added exemptions, specifically excluding coverage for these types of pandemics. There has been proposed legislation in New York mandating that these policies cover these types of claims. So far, that it doesn't seem like that legislation is getting very far. The insurance lobbies obviously pushing against that very hard, so it doesn't appear at this point that that's likely to pass. The big issue we've been seeing lately is face coverings, where businesses, what are their responsibilities for guests and people in their spaces. We first saw the governor pass Executive Order 202.17. And what that did was required face coverings when people were in public places and they couldn't maintain social distancing. Wasn't clear what penalties were in place, but that was the kind of first action we saw from the governor regarding face coverings in New York. He then followed that up with Executive Order 202.34. And what that did was basically affirm what was already in place, where businesses in New York, you have discretion to deny admittance to individuals that aren't in compliance with that first face covering requirement. Like sort of the no shirt, no shoes, no face covering, no service approach, where businesses can deny service to anyone as long as it's not discriminatory, and all that did was affirm that as well. Again, there really wasn't any mandated requirement that they had to deny admittance, so that really didn't do much in terms of any big changes. More recently, we did see a big change from the New York State Department of Health, and they issued a new regulation for businesses requiring and stating affirmatively that they shall deny admittance and shall require or compel people to be removed from their businesses if they're not complying with that initial executive order requiring face masks. The Department of Health can impose fines up to $1,000 per violation per day. So this is the first affirmative step we've seen from the state to actually threaten fines for businesses if they don't take steps to have people not in compliance removed from their business. That doesn't necessarily mean that they physically remove them. I imagine if a business simply asks them to leave, if someone refuses to leave the premises, they'd then be trespassing, and it's our recommendation that you call law enforcement to make sure you're in compliance there. All the above include exemptions for people under the age of 2 and people medically unable to tolerate a face covering. That creates the whole issue of Americans with Disabilities Act and a whole range of issues there. That doesn't necessarily mean that if someone claims they have a medical condition, they can walk through your business without a face mask unabated. Under the Americans with Disabilities Act, generally businesses are required to provide a reasonable accommodation for people that have medical conditions. So in this specific instance, businesses are only required to act reasonably from their perspective. So if someone claims they have a medical condition and can't wear a face covering, a face shield, a face mask, a piece of cloth, they claim they can't do any of that. It may be reasonable to say, well, if you can't wear a face covering, we're happy to offer delivery or curbside pickup, or if you're a service provider, consult with you by video. You don't necessarily have to or be required to have them move at will throughout your business and potentially risk exposure to other customers, yourselves and your staff. So sort of the key takeaways here in conclusion, in order to mitigate your claim, we recommend you follow all mandatory and recommended guidance, including what's specific for your industry. Make sure you're on the governor's reopening website. There's some great resources on there, including template written safety plans. We recommend that you obviously have one and then actually follow it. And along with that, make sure you document. The more you have in writing, the better defenses you have. And I imagine we're deep into this pandemic already. As you all know, the key is to stay updated and make revisions. This is a fluid situation. Things are changing. And at times it feels like you're drinking from a fire hose, but it's going to be a part-time job just to stay on top of these rules and regulations. And it's important that you stay abreast of that. Just wrapping up today in terms of this presentation, you should be relieved saying, oh, we're doing all these things. I feel good. I can sleep a little better tonight. If you're panicking right now, if you don't have a written safety plan, if you're not documenting things you're doing, the good news is that's something you can start today. And those are relatively easy changes you can make to help protect you and your business. So I do have my contact information up here if anyone has any sort of questions they want to ask me directly, but I'll open it up now to questions as well if anyone else wants to chime in on that presentation. Be happy to field questions now.
I guess my question would be, as it relates to the partnership and the Merchants Association office, is we just have people that, stop in and out. And obviously we ask them to have masks, but as far as I would be, even though we're much less, have many less guests than say a Wegmans, similarly, it would be really hard for us to log everybody that walks in.
Well, it's kind of a business decision on your part. If, it may be possible to, if you have a sign-in sheet, when people come in, they put down their name and phone number. That way there's no really burden on you or your staff. You allow a simple piece of paper at reception, and people note their name and contact information. That might be kind of a low-level suggestion to do that.
Would we be better off, Pam, just thinking out loud here, if we limited entrance in our case, to appointment only, and our other tourism walk-in functions have to basically be carried by an open kiosk of information in the lobby, and
Right.
just avoid anything other than scheduled interactions with known people, basically.
Right. So we would just we'll put signage up to that effect.
Yeah.
Okay.
Peter, do you have any examples, not to name names, but the types of concerns businesses have presented to you locally?
I apologize. I missed the tail end of that. Can you maybe speak a little closer to the microphone?
I was just wondering if you had examples to share, like a situation. I know you wouldn't want to share names, but a situation that your services have been involved with to manage during this time.
Sure. Well, we've kind of been involved in every phase. When things first started opening up, there was a big question of who's essential versus non-essential, and we had a client receive a cease and desist letter from the New York State Attorney General questioning whether or not they were essential or not. So we had some back and forth with them, arguing whether or not they were a convenience store. More recently, we've had a client have some issues with the state liquor authority with the new regulations about serving food as well. So we've been handling that. So it's a delicate balance, because I know businesses are already under a lot of stress and pressure from all angles, including financially. So trying to weigh bringing in an attorney and paying fees is a challenge as well. But we've been trying to stay on top of it too. But it seems almost daily we're getting questions and trying to find best practices. And it's the key takeaway here. We did an extensive waiver of liability for a client recently that's already engaging in a business that has risks because there's some physical interaction. But now there's this whole new coronavirus, so that spurred them to let's really do a broad, extensive waiver. And that's taken up a lot of time, but we're trying to convey that the waiver can be a good shield. It can help mitigate risk, but it's not bulletproof. So that's something we're trying to convey to our clients as well.
So Peter, I help run a resale shop. We feel we've done everything on the employee volunteer side, our safety plan. We're doing checks daily, but I'm just wondering about, we've been open, I think this will be starting our 6th week. We opened June 17th. And I'm just wondering, we do not have every customer sign in. We know who's there on an employee, limited employee, and we don't have we have like 80 volunteers. None of them are coming in except our intake people. So we've limited that to limit the exposure. But I have to believe over this point that somebody who's been in our store has probably tested positive. So I'm just wondering as a customer and a consumer, like what our responsibilities are to go back. Like we haven't gotten any calls saying I've tested positive. So I'm just wondering, what do you do then if somebody who's been a transient person in your store calls you and says they've tested positive?
Right. I believe if you are aware of a known positive case in your business, there may be a requirement to contact the Department of Health.
Okay.
I believe that may be a requirement. I'd have to confirm that. But that's the concern here for a lot of businesses is all of a sudden you get the Department of Health involved, and then there may be a notification to the media, because if you can't notify everyone that's been in your space, there may be some public notifications to let people know, and they're worried about impacts that may have on their business. As you said earlier, it may be a matter of time before this is, spreading throughout, and lots of businesses will get affected. There's kind of a PR perspective here as well. I've seen some local businesses that did have positive cases and said, we're aware of the cases. We were aware of the positive cases. This is what we've done. We've shut down. We've remediated. We're going to close for 48 hours, do a deep cleaning, reopen.
Yeah, that's what I've seen. And
I think most of the public is generally understanding of situations like that. There may be people that are just very risk adverse and will never venture out if they don't have to, and others that are trying to return to some sense of pre-pandemic normalcy that aren't concerned about the risks and will be there, first thing in the morning when you do reopen. So there's some real practical concerns in addition to the legal ones as well. And it's a tough field for all of us to navigate right now.
Yeah, and just the responsibility as a consumer too, because the more we're out, the more exposure we obviously have. So it's a lot to keep track of. And I don't know if you would suggest, obviously Wegmans is the Uber example, but somebody like our shop that's open 4 days a week, and maybe 50 people in that 6 hours we're open wander in the store to varying degrees of time. Like, would you recommend that we should? Because then you've got the privacy thing too. You got to shield the customer's name and address or phone number from the next person coming along. And so how do you?
That's unfortunately, that's where I defer to you and say it's a business decision. These are your risks. There's no bright line rule for this. I think I look to the back end and say, if you presented this to a jury, what would a jury say? And if you say, look, we're a busy retail shop, there's a lot of foot traffic, and we decided not to do that like a larger retailer. I think most jurors might consider that to be, reasonable in light of the fact that you're doing regular cleanings, you're requiring masks, you have signage, you're doing all those other things. So, it's the businesses that are flouting the rules, not requiring masks, no signage. Those are the ones that are, going to face the most potential exposure here. The fact that you're even on this call learning more is a good sign. It's the businesses that are willfully ignoring what they should be doing and state guidance that are going to be in trouble potentially.
Okay, thank you.
I have kind of the in specific example or just question. So we have use of our barn space, and it's DIY, meaning I'm not engaged in the event once I turn it over. In our contract, we have a sentence that says I will follow all current COVID-19 guidelines, New York State COVID-19 guidelines. But once I leave, I have no idea who is coming and going or whether or not they're actually following the rules. So again, should I have my host collect people's names?
Yeah, that's a good question. As a plaintiff's attorney that does personal injury cases, I would say, that the owners here are engaging in willful ignorance if they knew or should have known that rules might not be followed. So it might be challenging to say, we
Yes.
and pass liability along. I haven't reviewed that agreement. The exact language of the agreement might be key. But, if it's a private event that's up to 50 people, it may be reasonable to ask for a list of names, especially because you're trying to protect yourself as well. For private events, most people know who's coming, and they send out things like invitations and have contact information for their guests. So that might be a reasonable request to do in advance. I've done some work for some event spaces, and they've said that, you can limit it to 50 people. And the people who sign up for the event agree to that. And then all of a sudden, 80, 90, 100 people show up to the event. So that's another concern as well that we've seen for businesses in those types of spaces. Something to keep in mind. It's challenging because you don't want to be hands-on and you're just giving the space. But, I want to take a close look at that agreement and try and put as much protections as you can in there. Not only waivers of liability, but also assumptions of risk, saying, you are assuming responsibility and risk for this space, and it's all on you if anything happens. You want to make sure that that's crystal clear, almost as a short-term rental agreement for the day.
Which is basically what it is. And I'll engage you offline because
Right.
I do think we do have to protect. I mean, those are nerve-wracking for me.
Right. Yeah, that I see.
Tells me that there's risk.
Be concerning too. And then I'd also have concerns where after the event, how's the space going to be cleaned and sanitized for the next event? Who pays for that? So could be some potential issues there. Absolutely.
Okay, thank you.
Any other questions or concerns?
Peter, could you address for everybody in attendance the actual cost of engaging services such as yours? So for example, like a lot of us on here represent small organizations or small businesses without deep pockets. Are there opportunities up front for you to investigate insurances that might be able to afford that level of service, or other means, so that the requesting party would have a good idea up front what their financial obligation would be to move forward?
Is this for our firm or for retaining insurance? I apologize. I had trouble hearing.
Well, for your firm. So for example,
For our firm, okay. Yeah, so we offer a wide range of different structures depending on what the potential client's looking for, and we'll do our best to give you estimates up front. If it's something as simple as reviewing a document, we can do a flat fee consultation. Others that are more engaging and more time consuming, we usually do it on an hourly basis, and the rates vary depending on the attorneys in our firm. So our bread and butter is small and mid-sized businesses, so we understand those financial concerns and try and work with our clients the best we can. And I tell a lot of my clients it's sometimes worth spending some money up front if it can help prevent these big time-consuming, expensive lawsuits on the back end. I also tell a lot of my clients if they have some trepidation about engaging us, is do whatever's going to help you sleep at night. If it helps to have an attorney look something over or address some concerns and can get you a little bit more sleep, that's maybe the right business decision for you or your business. I also value sleep as a father of a toddler, so I'm a little biased there as well. So, but unfortunately, as we just went through, there are a wide range of issues, a wide range of things we can get involved with. So, if you reach out to me, let me know some idea of what your concerns are and what you're looking for. I can put a quote or estimate together to give you a ballpark of what we can do, and we do offer some flat fee consultations too to help kind of lock in and let you budget as well.
So with an organization or business that does have insurance, and hopefully we all do, is it possible that upfront that can be looked at so you know if some of your expenses would be covered by insurance?
Unfortunately, usually no. Usually, your liability policy will come into play only if there is a claim where someone says they're going to sue you or actually sues you. Then your insurance will get involved. They'll assign an attorney, pay for the attorney to defend that specific pending claim, and then pay out any potential settlement up to your policy limits. So that's something that actually usually irks me in a lot of these cases. Like, for example, for car accident cases, sometimes one of the parties will face a traffic ticket, and your auto insurance typically will not defend the underlying criminal charges. They'll only deal with the personal injury claim. So they because insurance companies pay for the attorneys, they try and limit their costs as well. So I would not expect your liability insurance company to pay for an attorney to consult with you up front for any potential issues. So I just wanted to, in conclusion, I just want to say my contact information is there on the screen. I'm also on LinkedIn. Feel free to add me. I post regular updates as things develop, both locally, statewide, and nationally. And it's a good way to stay up to date there. And if anyone else has any other questions or concerns, feel free to reach out to me by email. And I just want to thank you all for the opportunity and hope everyone stays safe out there.
Well, thank you, Peter. Thank you,
so
Peter.
much.
Yep.
Yeah.
Last chance if anybody's got questions for him, or he will be back on here tomorrow for round 2 at 3 p.m. So if you think of anything and want to jump back on here tomorrow, he will be back.
And congratulations to McConville, Constantine, Kuhlman, and Marin for being a double winner in the RBJ and Daily Record Reader Ranking for this year.
Thank you very much. Yes, best medical malpractice firm and best mediation firm. So if you or anyone you know knows anyone that's been injured by the negligence of others, feel free to reach out. We'd be happy to assist them. So thank you all, everyone. Have a great day. And I hope to see you in person one day at some networking events.
Thanks.
Sounds good, Peter. Thank you.
Thank you, Peter.
Bye-bye.
Thank you.